Welcome to DarshanTalks, powered by the Kulkarni Law Firm.
Hey everyone, welcome to another episode of Darshan Talks. I'm here with the famous Rebecca Tushnet. And Rebecca, I don't remember you having colored hair before, but I could just be mistaken. Is this a new look?
No, it's been a look for 4 or 5 months. So I'm enjoying it.
Very, very cool. I am excited as always to talk to you because you raised the level of discourse in our conversation. So thank you. The conversation we're hoping to have today, maybe we're going to start from the prenatal testing case that came out. Before we get started, Rebecca, do you want to talk a little bit about who you are, and then we'll get to the case.
My name is Rebecca Tushnet. I teach at Harvard, and my areas are copyright, trademark, and false advertising law. And I think our overlap here is mostly in the advertising space. And there's always something interesting going on in pharma and pharma-related areas. And so, today's candidate, I think, is a case against Natera, which is makes a diagnostic test that tests for non-invasively for various rare genetic conditions, as well as, I believe, for Down syndrome, which is not quite as rare. And so this is a really interesting kind of how to lie with statistics case, because the issue is this: the false positive and false negative rates, sensitivity and specificity, are very low, right? So every individual test is very good. However, except for Down syndrome, the base rate of these conditions that they're testing for is also extremely low. And this is a classic problem that's very hard for people to intuit their way around, which is, it sounds like this test should be very, very accurate. But when you apply a very, very accurate test to a population with an extremely low base rate, then even though the false positive rate is low, the number of false positives is going to be much bigger than the number of true positives. And you can show this with math, but it is very hard to make this stick to people's intuitions because, it's a very accurate test, right? So why wouldn't a very accurate test produce a result that was very likely to be correct? And the answer is, that's just not how the math plays out because of the very low base rate. And so last year, the New York Times did a big study, a story about how, if you got a positive result on one of these tests, except for Down syndrome, it was still quite likely that the baby did not have the condition, right? So, something, depending on what the condition was, could be much more likely or just more likely that it was a false positive. And the FDA got involved and said you had to do more disclosure of what's called the positive predictive value, right? So the positive predictive value is, given that you had a positive result, what's the chance it's actually positive? And that's a different number than the, sensitivity and specificity. And we'll see if that helps people understand. But it's a difficult concept, and judges struggle with it too. So the class action recently got the okay to continue. The courts seem to understand the math, which was good.
Here's my question. So if you are in this scenario from a pure advertising viewpoint, as you approach this, what is the duty of the company? What is the duty of the company? So an ethical requirement there versus the legal requirement of actually explaining, because it sounds like, number one, the FDA had not really opined on this in the past, so they're really clarifying what was unclear. So what was, at that point when the claims were made, what was the actual legal responsibility versus the ethical?
So, I mean, the responsibility is always not to mislead. And sometimes that means when you decide to say something, right, you don't have to say it, but once you say it, you need to say more. Because these, and especially for something like this, which is very high stakes decisions, people, consider abortion, right? They go through further testing. And, obviously, even, look, if you got a positive result on one of these things, of course you should be worried, but you should still be able to know this is step one. Right. There's still more testing that you need before you can conclude that, the fetus has this problem. And so I think this is actually a matter of sort of misleadingness by saying too little. So they say a lot about at least the materials last year, right? Said, oh, there are just very few false positives, right? There are very few false negatives. And that left out the fact that because of the low base rate, even though there are very few false positives, it was still more likely than not that if you got a positive, it was a false positive. And that's something that's very important to know.
Right.
Right. But not something that you can expect ordinary consumers to be familiar with. And precisely for that reason, if you start talking about how good your test is, right, you need to say more. And I think that's sort of basic misleadingness.
So that's kind of interesting, right? You talk about this basic misleadingness standard and the idea that if you put out some information, you have a duty to clarify. The question is, will people read just because you clarify?
Right. So I'm not a marketing expert, but this is the thing where the lawyer can be useful in saying, okay, marketers, right? How do we best communicate that this is a very accurate test, but if you get a positive result, that doesn't mean that the anomaly actually exists. And so if you get a positive result, the next step will be more testing. Right. And that's kind of the thing that you need to be able to convey. And hopefully, I mean, that's not super complicated compared to many other things that we need to communicate. So, this is step one is kind of useful.
And that's fair. This idea that if you're doing this, you need to take the next step. However, at what point do you go from sort of advertising to quote unquote the practice of medicine? And what I mean by that is to go from, oh, this is a test, but it is not the only test. This is step one of a multi-step process. Wouldn't you be going into more of a practice of medicine at that point, each step taking you closer?
So, I'm not an expert on the line here, but I don't see that, because the question is, what kind of test am I taking, right? Because we have experience with things where, and with the Down syndrome part of the test, this appears to be true, right? That because the base rate is high enough, you might be a false positive, right? There's some rate, but it's not a big concern for you. And precisely because of that difference from normal experience, right? Like COVID tests, right? The base rate's high enough, right? Or, a lot of tests where there's a screen first, right? So this is one reason that nobody ever, even people who would sort of have liked it in practice, mandatory HIV testing didn't get off the ground, because although sensitivity and specificity are quite high, the base rate for HIV is low enough that, you would be telling a bunch of people that, go for, some scary follow-up testing, and it wouldn't be true. Right. It's just not worth it.
And that's kind of interesting to me, right? Like you said, the standards, the expectations, the results from this type of testing are so high. People will consider abortions. People will consider taking pretty dramatic steps. The question then becomes, as we start considering these more dramatic steps, we're now in a situation where a class action lawsuit is being considered. And I guess my question is, and I don't know if you've looked into this before, but to the extent you know, is the standard different for advertising versus a class action lawsuit to succeed?
No, so the basic idea is it can proceed as a class action if you can resolve key issues on a class-wide basis, right? And so what this will really depend on is what the state's consumer protection law does. So in a number of significant states, particularly California, we basically have a rule that says if you show that this would have misled a reasonable person, you can presume that the entire class was misled. Right. And otherwise, if your state doesn't let you do that, then you can't have it as a class action because you have to show that each member was misled, and like the class action offers no benefits for that.
But and that's kind of fascinating to me, this idea that would a reasonable person have been misled?
Mhm.
I have multiple doctorates, including one in pharmacy, and I'm going, I don't fully understand exactly how these stats work out. So I'm not sure it's a question of misleading as much as I don't understand. So
So
what chance does a reasonable consumer have?
right. So I do think that there's a difference between sort of gobbledygook and misleadingness, although the line can be hard to draw. But I mean, the misleadingness part is, they say in the brochures, again, the previous brochures, they've now changed them. This test is 99% accurate, right? Like,
Right.
you can proceed with confidence, right?
Right.
And that's not really true for the things where you really care about it, right?
Right.
And it reminds me actually of a case from a couple years back about this pregnancy test that where the manufacturer wanted to advertise, it was how pregnant you were, right? So depending on what it showed, but unfortunately, because of the historical way we count pregnancy, the number that it gave was 2 weeks off what the doctor would say, and not for nothing, what the laws of your state about when you can get an abortion say. So
Wow.
you would think that you had 2 more weeks to make a
Oh my
decision than you
God.
actually did. Now, this was true. Like, technically, it was true because it did measure how long it had been from conception. But pregnancy is actually counted from -2 weeks from conception, which again nobody understands. And we do that because historically we didn't have hormone tests, right? So
Right.
for most of medicine, that's how you counted pregnancy, from the date of the last menstrual period.
Huh.
Uh,
So that it raises all kinds of interesting questions, and it sounds like we're still sort of debating this through. Which jurisdiction is this being argued in?
So the Natera case is in California, which does have these very capacious consumer protection laws, and the judge basically just denied a motion to dismiss. There's lots of ground left to cover. Uh,
Right.
uh,
So we're going to keep an eye out for this one as we continue. Another case you dealt with recently, Rebecca, was this Taste of Mexico case. Could you talk a little bit about that?
Yeah, so there are a couple of dueling Taste of Mexico cases, one in New York and one in California, and federal judges have disagreed about this. So the defendants sell these tortillas, and you may have seen them at your own grocery store. They're in plastic bags with a huge sort of Mexican flag or flag shaped and colored like a tortilla,
Yeah.
right? And it says Taste of Mexico, and then on the back, under the barcode, it says, made in New Jersey. So
Right.
the question is, would a reasonable consumer think that these came from Mexico, which, one might think has a better reputation for quality tortillas than New Jersey?
How dare you?
Uh, I mean, everyone's entitled to their own opinion. I'm just saying that it wouldn't be crazy for someone to think
I think that's
that,
fair. I think that's
that,
very fair.
uh, that they wanted Mexican tortillas. um,
Fair enough. So
uh,
what happened there? Yeah.
so in California, the court said, uh, uh, not sure about this, but I'm not sure. So let's do some fact finding. So, let's do some discovery. Let's do some surveys. What do reasonable consumers think when they see this? And the sort of black letter rule, it actually in both places, because in New York, the court disagreed, said no, a reasonable consumer would know that those were just sort of fripperies, and that if they cared about origin, they would need to turn the package over. And so the in both states, New York and California, the rule is the consumer is not required to check the back to contradict something that's on the front. But if the stuff on the front is just suggestive, then they may, if it sort of raises a question in their minds, they may need to turn the package over to answer that question. And that is obviously a line that is somewhat hard to draw. So,
Right.
if the court thinks that the stuff on the front of the package is just outright misleading, then you're not required to turn the package over to disconfirm it, because you're allowed to sort of rest on the clear message. But if it's just very ambiguous and maybe it means one thing, maybe it means another, then you can then you should be checking the back. My favorite, by the way, of these is there's a case about 1-a-day vitamins where they had one sort of subline where the recommended dose was 2, and the court said, that's just that does seem like straight up false advertising. Like, it says 1 a day. You shouldn't have to turn it over to figure out that you have to take 2.
It reminds me of, so I used to work at Rite Aid at one point, and Rite Aid used to have the 1-hour photo labs, and you never could get a photo done in 1 hour. It was just not possible. And someone asked, I remember someone telling her, it says 1-hour photo right there. And she went, no, that's just the name of the company. And to your point, it's the exact same concept.
Well, didn't work for 1 a day in that particular circumstance. The judge is like, that's a promise. 1 a day.
Yeah, exactly. But going back to the Taste of Mexico thing, how is that not either just straight up puffery, or I mean, how do you draw that line of, you know what, it may not be made in Mexico, but you've got this old abuela sort of in the factory making this, and why is that not good enough?
Right. So this is something that people fight about in a lot of different ways, including in trademark law, right? So, if your designer was born and bred in Paris, if they're now working in, Cambridge, can you still say, Parisian design?
Right.
And people, I think the law it has not come to a settled conclusion about it, in part because sometimes it might make a difference, right? So, and it might not in another case. So I think the argument here is, first of all, the tortilla company does not claim to have abuelas, lovingly making tortillas in the old Mexican style. And frankly, I'm not entirely confident that, Mexican tortillas are made in substantially different factories, right? Like, if you go into a supermarket in Mexico, it's not obvious to me that you'd get something very different. But people are entitled to have the preferences that they have, right? If they think that there's something magical about Mexican tortillas, then they're entitled to at least truth in that. So I think the question for puffery is, well, is it specific enough to be falsifiable? Right? Is it the kind of thing that consumers would care about? And I think the story here is actually, reasonable. That intuitively, it at least seems like the kind of thing that consumers might care about. So the judge in California said, let's go ahead, find out some facts on this, and the New York judges said, nope. If you care so much, turn it over. You have to do a little more work.
It reminds me a little bit of that, and I could be getting my Greek wrong here, but the ship of Theseus, where how many boards can you remove before you're not the same ship anymore?
Right. Well, and again, this at this stage of the case, right? The tortilla company is not saying, because it doesn't have the chance to say, actually it's the Mexican tradition, right? So that might be something we see in the California case, that as long as it's the traditional recipe, good enough, right? That might be true.
Right. And another way to frame this whole question, and again, I don't know if these are the facts of the case, but if the same company had a facility in Mexico and a facility in New Jersey and use the same recipe in both places, is it unreasonable to argue that if it's made in Mexico there, is the same exact recipe here?
Yeah, so it could well be. So a lot of it is what do we expect from food in grocery stores? So, for example, if I walked into a restaurant and saw a Taste of Mexico, right, I would probably have different expectations. On the other hand, stuff is imported from Mexico all the time, right?
Right.
So
Right.
like it's completely reasonable to expect that in your grocery store is some stuff from Mexico.
Right.
And so,
Right.
and I think that makes a difference.
So it's the reasonableness argument. And what I find fascinating is we as lawyers spent entire lifetimes focusing on specificity. And the only saving grace you have here is being as amorphous as possible and falling within that. Is it reasonable to make this argument? So I find that to be fascinating. Let's pick on one more case before we call it. The case I'm thinking of is the therapeutic grade argument that I've seen made. There was a case you talked about on your blog. By the way, before we go ahead, could you tell people where to find your blog? Because I read it as often as I can.
So it's at tushnet.blogspot.com. Right, I write about false advertising and intellectual property cases that interest me. So it's my own curated selection. Yeah, and this is a case that I wrote about these essential oils. So they're among the multi-level marketing schemes out there are people touting essential oils, and because of the structure of the industry, it's sort of the opposite of big pharma. Right. It's all these individual sellers, and they make ridiculous claims. And part of the business model is that the providers of the oils detach themselves from these claims to make it hard, right, to hold them liable for the things the individual sellers say. It's I think a very bad for truth kind of model because of those incentives. But one of the things they did say is they had various iterations of the sort of main MLM website, and they eventually got down to therapeutic grade oils, right? So they wouldn't say what it was therapy for, but there was the court revived, the Second Circuit revived a false advertising lawsuit saying, we can tell what you're doing here, right? There's a point at which what you intend to do, right, overwhelms your very careful language. Right. And when you say therapeutic grade, you are encouraging consumers to complete that in their head. Okay, therapeutic for, the thing that concerns me, especially since they have someone standing right there saying, oh, yes, it'll treat your headaches.
Right. Right. It reminds me of several situations where the FDA, I think it went all the way to the Supreme Court, where the Supreme Court eventually came up with the difference between the label and labeling, and this idea that the label is whatever is actually physically attached to the actual bottle, while labeling is anything that accompanies the bottle, i.e. your sales rep or a book that you might give along with that article. Isn't this exactly the same situation? Isn't this litigated at this point? Do we not know the answer?
So I think the answer is because of the appalling underregulation of supplements and sort of alternative treatments, it gets nothing like the scrutiny that either labels or labeling do. Right? I think we would probably be better off as a country if we did some of that. But I mean, you're absolutely right. What they're trying to do is leverage the difference between what they are saying and what the individual selling on sort of on the street level are saying, and at a certain point courts will say, no, we see you.
I love how you phrase that, we see you, which is usually an affirmative statement. This is not this time you want to be seen. But let me ask you this question. So why has there been a lack of enforcement against individual practitioners for these types of fraudulent claims? And this is not me making a political statement, but we saw a lot of that during COVID, where people were saying things like silver will cure this and all of those different versions. So how is this different, or is it not different? There's just too much to enforce.
So there's a lot out there, right? And our enforcers don't have the resources. But I will say there actually are some criminal proceedings. So, part of this is that the COVID stuff, we're just like getting around to charging people and sending them to jail for some of these schemes, but it is happening. The difficulty for the criminal part is proving intent, right? So again, the target seller for these MLMs is someone, who wants financial independence, but, doesn't have the traditional credentials and so, it's actually can be quite hard to prove that they knew what they were saying was false, instead of just being super hopeful. And sort of saying what they had heard, right? And if they have these, meetings where everybody sort of pumps each other up, and if one of the people sitting next to you is saying, I sold a bunch of lavender, I tell people, right, it treats depression, right, then you're gonna try it. And it's hard to find the level, the mental state, even though they shouldn't be doing it, and it doesn't actually treat your depression, right?
We just discussed this importance of being representative of the facts, and we talked a little bit about, in the case of the Natera case, we talked about the dramatic impact that can have. Using this therapeutic grade discussion in the context of Natera, what I'm thinking about is people who have cancer, sort of a stage 4, you're struggling, you're running out of options. You'll see exactly these conversations happen where you go, I don't have options, I will consider anything. Do you see any desire by any organization to try to regulate or minimize the not freeloading, but sort of people who are coming in saying, I will give you hope when I have no basis of giving you hope, and basing purely on my license or the like?
So my sense is that the FTC would love to do more in this space, and just is, resource constrained, and also, understandably trying to go after the bigger fish. So I think there is some increased attention to MLMs, and but one of the ways that MLMs have responded is by stripping down their own claims, right? So we're just selling this fun-smelling stuff, right? And
Right.
and we don't tell anyone to say anything else about it. And that's a challenge of regulation, because we've set up a regulatory system that lets the MLM business model off the hook for a lot of things that its individual sellers might be saying. But I think we have seen a very aggressive FTC. I think they're trying to go after it, when they find it. And frankly, I think that this also shows the need for still having a class action mechanism, because it's kind of the only way that there's any chance of getting change.
Wonderful. Rebecca, thank you so much for coming on. Thank you for a wonderful conversation.
Thank
Any
you for
parting
having
words?
me. Oof. Watch Severance.
Ooh, we'll talk about that offline.
All right.
Thank you again.
All right. Thank you.